Hello and good afternoon. My name is Randy Turner and I'm with the Governor's Committee on People with Disabilities, and I'm the Accessibility and Disability Rights Coordinator. This session is being recorded. Should you have questions, please post them in the Q&A box. I'm excited to bring you the second in a series of webinars this month. July marks the 30th anniversary of the signing of the Americans with Disabilities Act. 21 agencies and organizations from across the state are celebrating with a series of virtual workshops throughout the month, culminating in a big Texas-style celebration on July 24th. We will bring you a series of notable disability advocates sharing their experience with the ADA, what it was like to see it implemented, how it has furthered their civil rights of Americans with disabilities, and where we still need to go from there. After that, we will take a virtual tour of Texas with brief ADA birthday wishes from local disability advocates across the state. I will put a link in the chat feature so that you can connect to that event and register. So today's topic is web accessibility, and our speakers are Lainey Feingold and Sharron Rush. I'd like to thank our partners, and at the end we will show you a slide with the names all spelled out. These are just the logos. So for right now, I'm going to go ahead and turn it over to Sharron Rush.
Thank you, Randy. It's wonderful to be here. I'm Sharron Rush, and we're going to talk about disability rights and the digital future today, and I'm really pleased to welcome my friend Lainey Feingold. I think most of the folks at your Texas state agencies know about Knowbility. I'm the executive director and co-founder, and we put on a conference every year called Access U, and for many years Lainey has come and done our legal update. Lainey's a great person to have conversation with, and so I'm really excited to have her here today to talk with us about disability rights and the digital future. Lainey, you want to introduce yourself before we get started?
Yes, thank you. Thank you for inviting me, and great to be in conversation with my friend Sharron Rush. I'm Lainey Feingold. I have up on the slide my Twitter, which is @LFLegal, and my website is lflegal.com. And the reason I have such a great brand is sort of part of my philosophy of how I want to be a lawyer. It's that my friend Josh Mealy, who's blind, when I was putting up my website 10 years ago, said, and I was going to call it LaineyFeingold.com. And Josh said, no one will know how to spell Lainey, no one will know how to spell Feingold, and it won't fit on a line of Braille. And because I listened to my friend and user, I have a brand, even though I work for myself and by myself. So I've been a disability rights lawyer, client-centered in the digital accessibility space since the mid-1990s. And like I said, there's a lot of information on my website and on Twitter, and I invite you to look at it. I believe in collaboration. I've written a book about how to advance digital accessibility and problem solve without lawsuits. It's called Structured Negotiation, a winning alternative to lawsuits. And I do a lot of public speaking on some of the topics we're going to talk about today. So thanks for having me.
Well, thanks for being here. I'm looking forward to this. As I said, when Lainey comes to Access U, I learn even though she's been there several years in a row, I learn something every year, and even in preparing for this, I've learned something. So, Randy, if we can see the next slide, it lists the things that we think we're going to talk about today, and I say we think we're going to because we definitely want to hear from you all and why you're here. So this is a list of the topics that we have, but before we do, can we hear a little bit about who you are? We have a poll up here that we're gonna show, and take a minute for you to tell us a little bit about who you are. If you don't find, there's a limited number of things that we can ask on this poll. So if you don't find your role anywhere in here, feel free to put it in the chat, So please, please take a minute. And Randy, are you going to read the poll, or do we feel like people can see it?
I will show it in just 1 second. People
I
are
noticed
still,
it said hosts and panelists cannot vote, so we won't.
people
we
are
don't get
still
to vote.
logging in there. I see the
That's
numbers
right.
continue to
So
rise.
the possibilities are, we ask what role brings you to this conversation, and you can check more than one of these. Are you an accessibility coordinator for a government agency or higher ed? Are you a corporate diversity and inclusion accessibility role? Are you a policymaker, K-12 educator, higher ed educator, disability or accessibility advocate or evangelist? Digital accessibility consultant? Are you a small business owner or manager, a lawyer? Are you a web professional, developer, designer, content provider? So Julie says none of these roles fit. So please, if you have a role that doesn't fit, feel free to put that in the chat. Disabilities research scientist. That's an interesting one. Yes, yes.
We have vocational rehabilitation counselor in the chat as well. There's several VR associated.
So how long do we leave the poll open, Randy, before
I can
we
end it right now. And I'll share the results.
So quite a few are our friends from government agencies who are trying to be accessibility coordinators in those large or small organizations, always with different resources. A lot of corporate and diversity inclusion roles.
A lot of disability advocates, disability accessibility advocate evangelist is our highest percentage at 40%.
So this is great. It's great to know who's here. I also wanted to wave to a couple of good friends I know are here. John Slayton was an early mentor to our team, and Peter Slayton, his brother, is here today. Ann Forrest, who's an advisor to Knowbility, is here today. I'm glad to see old friends and new ones. We're going to talk, of course, about the ADA highlights. We're here celebrating 30 years of the ADA, and we're not sure how many years of digital accessibility, but we're going to talk about how those are related. We're going to look at standards kind of briefly. We're going to talk about the risks to the ADA intention. What was the intention of the ADA, and how are we actually enforcing or regulating that? We want to look at some best practices. And then we want to look forward and say, what do we see coming in what does the future hold for the next 30 years of digital accessibility? And of course, as we go on, your questions and comments are very welcome in the Q&A box. I think Randy said that's the way we're going to we're going to make sure that we see those and address those questions and make sure that you're part of the conversation.
Sharron, can I jump in for a second?
Of course.
Yeah, so two things. One, I love all the roles and people who put their roles in chat. And one of the things I often do to explain how accessibility matters is bake some cookies. And the cookies have a lot of ingredients. We'll talk about that later. But one reason for the ingredients is there's so many roles that contribute to inclusive digital environment. And so whatever your role is, I just want to say, like, hats off to you for knowing about accessibility, caring about accessibility, wanting to learn more. So that's really good. And I just learned something from the chat, which is even though the poll is accessible to screen reader users, the results are not, according to one of the comments in the chat. So Randy, can you read those results?
Yes, ma'am. I was about to type them in there, but it would be easier to read them.
Yeah, reading would be good.
So,
yeah, thank you. I'm sorry that we didn't know that. So
that's okay.
We're always learning. We're always learning.
So
it's
the top numbers were 40% was disability or accessibility advocate evangelist. Then we come in at 21% with the accessibility coordinator for government agencies or higher ed. Then 21, let's see, then we have 18% at web professional, developers, designers, content providers. Then we have a 12% disability accessibility consultant. Then 11% is corporate diversity and inclusion accessibility role. Then at 10%, we have small business owner or manager. Then at 4%, we have policymakers. 3% is, also 4% is lawyer. And then the smallest group here today are K through 12 or higher ed education or administrators.
So Randy, there was another question in the chat about the choice not to provide ASL interpreters.
We don't typically do that through Zoom because you can dial in with video relay service for ASL interpreter services. We didn't get a request to my knowledge for one for the session, so we typically provide CART.
Okay.
So I apologize.
So I'm sorry, and maybe next time we'll be more more proactive about asking if people want that service. So we do have another poll after we were looking at the topics, and our next slide kind of sets us off with the question about the ADA and its relation to digital accessibility. So our next poll question is, when the ADA was passed, how many websites were there? So this is just a guessing game. This is one of the things I learned from this conversation with Lainey already. So how many websites were online when the ADA was signed into law, which is 1990?
And our options are none, 10, 27, 52, or around 100.
Or I guess we should have said around 1,000.
Numbers are still coming in. Give it another second. We have 285 people on, so I'm trying to make sure everybody gets a chance to throw their numbers in. All right, looks like we've kind of stopped. So here are the results. None was 40%, 17%, I'm sorry, 23% was around 100, 17% said 10, 12% said 52, and 8% said 27. So what's the answer, Sharron?
So the right answer is that the first website was published by Tim Berners-Lee in 1991. So at the time of the signing of the ADA, there were no websites in the way that we think of websites. There were connections like ARPANET, but there were no websites. The World Wide Web was still just a theory. It was a gleam in the eye of Tim Berners-Lee. And 2 years after the signing of the ADA, those numbers went all the way up to 10. So within 2 years, there were 10 websites. And I found that fascinating. So with that in mind, Lainey, that there were actually no websites as we know it when the ADA was signed, how can we expect that the ADA will have anything relevant to say about websites or any other digital technology for that matter?
Yeah, that's a great question. And that's kind of part of the ADA 30 celebration. Before I answer it, Randy, there's some confusion amongst myself too. The chat, can people's audience members see each other's chat or only the panelist chat?
Only the panelists can see the chat. This is just one of the features that we have established because of some of the quote unquote Zoom bombing that has happened, where people have put inappropriate things in the chat box or have taken over the screen and things like that. So that's the reason that only the panelists see the chat. I would be happy to cut and paste information in there if it is important.
And so when the When the slides are posted and the recording is up, will there be a transcript of the chat?
I'm sorry, say that again.
Will the chat be available in the?
It is available. Sure, you can get a
afterwards.
copy of the chat afterwards. Absolutely.
Okay, great.
Okay, so back to the relevance of the ADA and the technology like Zoom that didn't exist back in the day, right? So I would say that the ADA is extremely relevant to accessibility because they are both about inclusion, they are both about participation, and they're both about non-discrimination. So the reason we all care about accessibility is because we do not want to leave disabled people out of not just the conversation, but of everything that is online, which now is everything. And the ADA from the very beginning had enough flexibility to, I don't want to say predict the future, but there's a couple parts that I just wanted to read. So the ADA is about not discriminating. And the idea was that no qualified individual with a disability shall, because of the disability, be excluded from participating or denied the benefits of activities of government agencies, public, private accommodations, and higher ed, everything covered by the ADA. So, like I said, web access, mobile access, it's all about participating in getting the services, the programs, the activities of everything that we rely on today in the digital world. But even more specific than that, the original ADA said that it was discrimination that if an organization covered by the ADA, like a business or a school, if they didn't take such steps that may be necessary to ensure that no disabled person is excluded or segregated or treated differently because of the absence of auxiliary aids and services. So this was back in 1990. And what did they define auxiliary aids and services are? You know, they talked about, say for blind people, taped text. Well, nobody relies on tapes anymore. Most of us don't. But the ADA was so flexible and so farsighted that auxiliary aids included effective methods of making visually delivered materials available to individuals with visual impairments. So making visually delivered materials, which is so much about the web is like, making them available to people with visual impairments. How do we do that? Accessibility. Same true for people with hearing impairments, people who are deaf. The original ADA back in 1990 said that it was discrimination if you didn't do what needed to be done to make things that are usually heard available to hearing impaired people. For that reason, I have my first prop, which is my stretchy band, because the ADA was written to be extremely flexible. And the reason this isn't just like one straight out thing, but rather a circle, is because from the beginning, the ADA also recognized that businesses or schools didn't have to do anything that would be an undue burden. They didn't have to do anything that would be a fundamental alteration, but they did have to do what was necessary to avoid discrimination. So all those principles have been baked into the ADA from the very beginning.
Well, those principles sound really great and really lofty. You know, the idea of civil rights and non-discrimination. I mean, there's no doubt those are wonderful things to aspire to. And when we were preparing and you were telling me about it, it reminded me of recently during the July 4th celebration, and of course because of all the attention to the fact that Black Lives Matter. I heard a Frederick Douglass speech that he gave one July 4th before the end of slavery. I think Randy's going to put the text of that speech in the chat or in the QA. But in there, he eloquently praised the ideals of the U.S. Constitution. He said, you know, the men who wrote it were great men. He lauded the evolution in human society that made those principles possible. and it was a beautiful speech, because then just as eloquently, he identifies the ways in which the United States had failed to live up to those ideals. And I wonder if we can say the same thing here. Has the ADA, yes, there are these grand stated ideals of non-discrimination and civil rights, but has it actually been useful as a tool in advancing digital accessibility? Do you see that it has helped to fulfill the promise of the ADA?
I'm going to say yes to that as well. I think people who know me know that I'm an optimist. And Helen Keller was also an optimist. And she said nothing can be accomplished without hope and optimism. So is there still a lot of work to be done? Yes. Is it a journey? Yes. Should we be further along? Yes. However, not quite at 1990, but in the 90s, the ADA was recognized to deal with website accessibility. And I have just a couple of highlights that I think we'll have the links in the Q&A or the chat. But in 1996, the US Department of Justice, Deval Patrick, who was head of the Civil Rights Division, he wrote a letter to Tom Harkin about web accessibility, in which he said that if you're covered by the ADA, you're required to provide effective communication, regardless of whether people generally communicate through print media, audio media, or computerized media such as the internet. That's 1996, at which time there were 257,000 websites. What we didn't ask is how many websites are there today? First of all, you got to go to the link. We should put that in the chat too, that tells you how many websites, and it's like a ticker. It's moving as you see it. So today there's like over almost 2 billion, like 1.75 billion, 1,783 million. So yeah, so this is back in 1996, and Deval Patrick also said, the internet is an excellent source of information, and of course, people with disabilities should have access to it as effectively as people without disabilities. And then he goes on, a number of websites provide information about accessibility of web pages, including information about new development and guidelines for development of accessible web pages. So we'll put the link to that in, but that's 1996. The ADA was already talking about the importance of web accessibility as a non-discrimination principle. In 2000, the Department of Justice filed a brief in court about, it was a case against an online only, I think it was like a gambling site or a bridge site where you play bridge, and somebody sued not about accessibility, but about being discriminated on the site. And in 2000, the Department of Justice said a commercial business providing services solely over the internet is subject to the ADA's prohibition against discrimination. So even early on, so also in 2000, which shockingly is 20 years ago, that was the first, that was the year that I was involved in negotiating the very first web accessibility agreement in the United States. It was with Bank America and some of its blind customers, as well as California Council of the Blind. On lflegal.com, you can find the article I wrote this year about that 20th anniversary of the very first web accessibility agreement. In structured negotiation, we didn't have to do a lawsuit. No judge said anything, but the ADA was our foundation for that agreement. Also in 2020 years ago, the very first lawsuit about web accessibility, which was against AOL, filed by the National Federation of the Blind, that was settled for accessibility. In our Bank America settlement, we actually referenced WCAG, the Web Content Accessibility Guidelines 1.0, that was in 2000. When were those? I think that was also 1999 was the first WCAG. So these are not new things, even though—
No, but Lainey did that. So you referenced WCAG, but did you reference the ADA?
Well, our agreements are reached through collaboration. So none of our companies, we don't ask companies to say, yes, I violated the ADA, because that doesn't really matter. That's why
Okay.
it's like, when I say a foundation, I mean, it makes it all possible. But as we'll talk throughout our time together, too much focus on the legal, you violated the ADA, you didn't, takes away from the ability of accessibility to be a creative and flexible and forward thinking. So yeah, I'm sure the ADA was in there somewhere, but not, it was there as a foundation. Nothing I have done, even though I haven't done lawsuits, would have been possible without the Americans with Disabilities Act.
Okay.
That very first web accessibility agreement in 2000. In 2003, which I guess was 17 years ago, the Department of Justice published accessibility of state and local government websites to people with disabilities. That was 2003 under the ADA. Then the DOJ has a whole Project Civic Action where they settled with state and local government entities saying that you have to make your websites accessible. That was started in 2005. And then starting in 2008, which was 8 years after the first settlements that we did, you start seeing more lawsuits recognizing it. So the Target lawsuit was in 2008. The Netflix lawsuit was in 2012, which said even Netflix, which didn't have a building, had to have captioning on their videos under the ADA. In 2010, we had the first settlement agreement on mobile apps, which we did in structured negotiation with Major League Baseball. They were a great partner throughout. So this is all just by way of saying that the ADA has been there for digital accessibility right from the beginning. And all these things that were accomplished up until today were accomplished with different strategies. And I just want to say a quick thing about strategies, which is, as you could see from what we just talked about, government agency activity. Department of Justice has been a great ally, of course, not in this administration, but throughout the ADA's lifespan. Civil rights lawsuits have been critical, like Target, Netflix, so important. Structured negotiation has been a collaborative way for accessibility. And one strategy that is often overlooked is the fact that individuals, disabled people, advocates are using the ADA, even if they don't know they're using the ADA. One of the reasons I try to do a lot of public speaking around the law is because I think that we all have to be able to have the law in our pocket, have the law in our toolkit, know that this incredible civil rights law is there to support accessibility. So that's kind of how the ADA has been used. But Sharron, I'm interested in, when did you first start getting involved in accessibility, and when did you start thinking that the ADA might be part of the work that you were doing?
Well, yeah, that's true. I didn't start from the ADA at all. I was working at Easter Seals, and I was trying to develop employment programs for people with disabilities at a time when Austin was transforming itself into a tech hub. So I came at it from the technology point of view. I want people with disabilities to be able to work in this new technology. And why can't they? Oh, because there are these barriers in the way that it's constructed. And my thinking then was that if you get the technologists involved in the problem, that it would be solved. And that's why we started the Accessibility Internet Rally as a community collaboration, a contest. We thought, well, if we get the developers to compete to be the best accessible designers, then we're going to solve the problem. And it was actually several years before. In fact, I'll put, since you asked me, I will say the Accessibility Internet Rally is still going today. And we have just opened registration. So if you want to learn about accessible design techniques in the context of a very fun, friendly community collaboration, go to air-rallies.org and sign up a team. It's a really great way to learn and apply accessible design techniques in a way where you get mentoring and learn a lot and also help a nonprofit organization. But so that's what I did. And the competition, the AIR rally itself was pretty great about engaging that sort of creative spirit of technologists to solve problems, and it sort of took on a life of its own. And that's really the reason we started Knowbility, because Easter Seals, after a couple of years of this contest, said, wait a minute, we're not a technology organization. This isn't what we do. We do rehab. And here we were in startup Boston. So I said, okay, well, we'll start a nonprofit. And that's what we did. And it was only a couple of years into it. John Slayton, who I mentioned, and Jim Thatcher were great mentors to Knowbility in the beginning. And of course, Jim Thatcher, with his career at IBM, had become very involved in some of the legal challenges. And he's the one who kind of cued me into the fact that, you know, you don't have to just rely on the creative energy of technologists. If they don't do what they're supposed to do, there's the ADA in their back pocket, you know, and so, yeah, it was a couple years into our whole effort that I started thinking about it in terms of civil rights, but it is very, very powerful. I can certainly attest to that fact. Jim was also John Slayton was the one who suggested that I get involved with the W3C to help develop the standards. And I think the next slide, Randy, is just the screenshot of the W3C Way Web Accessibility Initiative website, and that's where they live. That's where the WCAG, the Web Content Accessibility Guidelines. And the first version of that was announced on May 5th of 1999. So 1999 was a real banner year. That's when Knowbility got started too. But that was 9 years after the ADA was passed. And since that time, those guidelines have had a couple of iterations, and WCAG, or the Web Content Accessibility Guidelines, are explicitly referenced in the European Directive for Accessibility for the European Union. They're explicitly referenced in the UN Convention on the Rights of People with Disabilities. But as far as I know, they've never been adopted as the official regulation of the ADA, have they, Lainey? So what is the relationship of the WCAG guidelines to the ADA? Is there a role for them in ADA enforcement, or even though they're not part of the official regs, do you think?
Yeah, there were several people asking about that in the chat, and many of you remembered, as do I, that the US Department of Justice announced in 2010, which somehow was 10 years ago, that they wanted to make regulations to specifically say that how do you do web accessibility under the ADA? Because like we saw before, it's baked into the principles and it's baked into the effective communication regulations that you have to effectively communicate. The only way to do that is with accessibility, but we do not have WCAG 2.1 or 2. anything in the ADA regulations for government or for private sector. And I frequently say that the ADA is alive. The web regulations are dead, but the ADA is alive and well. So they just couldn't get them out before the end of the Obama administration. And then, of course, there were no new regulations under the current administration. But they have a role nonetheless. Even though I say the ADA is alive and well, web regs are dead, I know that many of you on this call, it would be so much easier if you could point to the ADA and say, look, here it is, WCAG 2.1, end of story. It's not so easy, but it's clear the courts are recognizing that complying with WCAG is a way to meet, is the most effective way to meet the effective communication requirements. So you have to make sure, like we said, that if it's visual, there needs to be a way for blind people to access. If it's oral, what they call oral, there needs to be a way for deaf people to access. And in the recent case against Domino's that went to the Supreme Court, there's two things important about Domino's here. One is Domino's Pizza tried to get a web accessibility case thrown out of court because there were no regulations, because WCAG had never been adopted specifically into the ADA. And courts around the country were saying it doesn't matter. They don't have to be specifically adopted. But Domino's kept fighting all the way to the Supreme Court, and the Supreme Court said, we're not going to look at this. So in the Domino's case, it's what the appeals court said. And what the appeals court said was that the plaintiff was not seeking to impose liability based on Domino's failure to comply with WCAG. But the plaintiff argues, and we agree, that the court can order compliance with WCAG, at the time it was 2.0, as an equitable remedy, which means a way of meeting the ADA obligations. If after, they spent all this money in discovery, it turns out that the web and the app don't meet the ADA standards. So the WCAG, it would be better. It would be easier for many of you if, as Sharron said, like the European directive, ADA specifically said it, but the ADA doesn't specifically need to say it because we have effective communication. All the courts are recognizing we don't need specific regulations, and that WCAG is, WCAG is the best way. I don't want to say the only way, because you know how courts are. They say, well, maybe there might be some other way. So far, there's not been another way, and there isn't another way. So WCAG is the way. I should have said something at the beginning, so I'm going to say it retroactively. In all the talks that I do, even though I'm a lawyer, this is not legal advice. So I share this information generally because I think it's important for all of us to know. But if you think you have a legal issue on one side or the other, make sure you talk to an actual lawyer and don't rely on this. So, okay, that's what I have to say. That's what I have to say.
Your disclaimer. There's your disclaimer.
That's my disclaimer. But I want to know, Sharron, you are head of the Education Outreach Working Group of the Web Accessibility Initiative, which I don't know if all of you out there know how incredibly hard these volunteers work to make the web accessibility and the WCAG available to all of us who need to use it. The resources are phenomenal. And so what do you think about the role of WCAG? What do you think?
Well, I think the key for you there in your question is, the key answer is, I am not co-chair of WCAG. I am co-chair of Education and Outreach Working Group, because I think the WCAG is not really very helpful for developers or practitioners. And I think you and I have a little bit of a disagreement about, WCAG is very important as a policy document, but it cannot solve, like we just got a question in the QA, for performance reasons, sometimes animations are replaced with video clips. What is the proper way to capture an animation in a video if it is for design only? Now, we're not going to answer that question today because it's outside of our scope, but you will not find the answer to that in the guidelines either. And what you need, what developers need, designers, project managers, they need those documents that actually tell you how can you apply the principles. The people who need, so there are poor principles. That's what developers need to understand. Poor principles: perceivable, operable, understandable, robust. I would say those kind of correlate with what you said about the civil rights guarantees of the ADA. So the guidelines try to get us to this perceivable, operable, understandable, and robust, realizing those principles. But technology changes quickly, and the guidelines don't always keep up. And so I think better for you to use, and so the screenshot of the homepage shows there are different roles there for you to, if you are a developer, if you're a designer, if you are an advocate, you have different sort of channels that you can follow, and we try to provide resources that actually help you apply the guidelines in a way that helps you meet the principles, because the principles are really the most important thing. I actually sent another link to one of the questions on the chat asking about, if I complain to an organization that their website is not accessible and I don't get good results, well, then where am I left? And, I said, Lainey might be willing to chime in, but in the meantime, there's a resource on the WAY site that says, here's how you write to organizations with inaccessible websites. So I really recommend this, and we have another poll to see if anybody, if you've heard about this WAY website, if you've ever seen it, if you've ever used it. So Randy, can you launch the poll about so do you use the WAY website at w3.org/way in your work or in your advocacy? So I would be very interested to hear how many never have, or maybe have once in a while checked in.
There's a lot. There's a lot clicking on never have. I'll share the results here in just a second.
Maybe only to get to WCAG, or you've used many of the resources. I would love to hear that was true, or it's my favorite website in the whole wide web.
Okay, we still have people responding, but right now, never have is at the top. Have but not often is next. Yes, have never, yes, has used many resources. Only to get to WCAG, and only 2 people have said it's my favorite site in the world.
And one of those is Brent Bakken, who's my co-chair on education and outreach, I'm pretty sure.
Well, 60%.
Brent.
I need to speak to this so it doesn't sound self-serving, because I am not a member of the working group. 60% of the people answering this poll said they have never gone to the website, 107 people. And another 30 people, 17%, said I have, but not often. And then it goes down to 6% only to get to WCAG. And only 29 people, 16%, said they've used many resources. And like Randy said, too, it's their favorite website in the world. This is an amazing website. And perhaps maybe you went to it once a long time ago and you haven't seen the refresh and the redesign over when was that, within the last 2 years. I am constantly in my work, and I mean constantly. Every new company I work with, anytime a company calls me with a question, I say, start with the w3.org/WAI, because not only are the resources great and responsible, but they're free. And there is so much out there where you can get the same stuff for a lot of money. So for those that pull us down, but for those 60%, there's your homework assignment. Check it out.
Well, and just as luck would have it, Knowbility does a monthly workshop where we do deep dives into certain accessibility topics. We usually charge somewhere between, I don't know, $200 and $350, depending on the topic and how much we have to pay the speakers and all that. Well, in July, as a celebration of the ADA, we have staff members of, not the volunteers, but the staff who actually build and recognize these. We are doing that workshop for $30, where you can spend all day with their staff. They'll walk you through how to do evaluations using their tools, how to do all that. I think the date, I'm not sure, I think it's July 23rd. Maybe July 28th. Anyway, it would be on the knowbility.org website, but for $30, you can get a grand tour of all these great resources. And that was the end of my self-serving commercial.
Okay.
Oh, Becky just prompted me. Becky Gibson just said it's July 23rd. So there we go. There we go. So
yeah.
Where are we now? Do we have any questions in the chat that we should, in the QA, Randy, that we should address before we move on? Or
I think, Sharon, we should do a little more and then look at the chat. I'm trying to stay on top of it a little bit, but let's, because I knew this was going to happen, because I knew we had so much we could chat about.
Okay.
So let's switch over and talk about ethics. Let's talk about ethics.
Oh yeah, because you were the one, when we were planning this, you said, well, when I said the WCAG doesn't always get applied properly, you said, yeah, and one result of that, because the WCAG is not really properly, or people don't understand its purpose, that it gets applied in this way that results in unethical behavior, right? Toward companies who are trying to do the right thing. And I was going to ask you to share with the group what was your view, because I've always been a big admirer of that strategy of structured negotiation. You know, let's stay out of court. Let's figure out how we can make people happy who have business concerns, but also we need to meet the needs of people with disabilities. I've always thought your strategy was brilliant and very humane. And so with having that as your operating principle, what do you see happening with these, you know, what people are calling drive-by lawsuits and that sort of unethical behavior? What are the dangers to the ADA in that sort of behavior?
Yeah, so we have this unbelievable slide that Sharron found with a picture of a law office with a shark, a toothsome shark coming out 3D, sticking out of the law office. Yeah, thank you for your kind words about structured negotiation. I do feel that it's really important for me to say, as I think I've already said, but I'm going to say again, that there have been many strategies that have allowed the ADA to be effective for digital accessibility. I was reminded in the chat that one of those strategies is, for ADA generally, is direct action, and the work that ADAPT does on-site protests, things like that, the work the government has done, and civil rights lawsuits. Lawsuits have been a really important tool. I feel privileged that I have worked with clients and companies that haven't required us to go the lawsuit route, but lawsuits are a fundamental, important component of the ADA and its role in digital accessibility. However, there have begun since 2017 a new type of lawsuit that is, and I actually brought my own little shark. Let's see, just, I have my shark because I do whole presentations on the importance of being a dolphin and not being a shark. So I've written an article on the ethics of this, and we don't have time to go through the whole thing now, but I think it's very important to have the vocabulary to distinguish lawsuits that, for many reasons, appear to be focused on quick money, quick settlement, not really about fixing and maintaining the underlying problems. And in my article, which I think is going to be in the chat with the link, I go through various things to look at. You know, if someone's filing 50 lawsuits or 50 demand letters in 1 week, I can tell you from 25, 30 years of experience, you cannot work with an organization in that amount of time in those kinds of lawsuits. That's like one of the red flags around the ethics. So I really encourage us to have the vocabulary. I used to be afraid of talking in a negative way about any kind of lawsuit because the civil rights lawsuits are so important. I mean, right now there's a ton of lawsuits on web accessibility for voting. So blind people have the right to vote independently. So the civil rights lawsuits are critical, but we have to find the vocabulary, I think, to make sure the ADA stays strong, because there can be seen advantages. Yes, we have more attention on web accessibility now, but accessibility and the ADA are about disabled people. This law never would have passed had disabled people not fought, had not crawled up the Capitol steps, had not done years of organizing to get this law passed. And there's a certain type of lawsuit that forgets all about the people. So I just think we have to pay attention to that and keep the ADA protections strong. One of the things I'm concerned about is that these kinds of lawsuits, they paint us all with the same brush. Oh,
well, but Lainey, I wonder if you had told me when we were preparing that you had some people comment that there were actually some benefits to them. Some benefits to the drive-by lawsuits. Do you see any?
This is why I wrote my article. It's long. It's like too long. Don't read, that little expression people have. But it's a very nuanced subject. So yes, the lawsuits are bringing attention to the issue, and sometimes the lawsuits have some of them have resulted in court orders. However, most of them are quickly settled with no transparency, which is another red flag.
Oh yeah.
you know, so we don't really know what's happening. You read class action filed against company for $10 million. The next thing you know, it's settled. You don't know what happened. So I think transparency is important, but I invite participants to either put in the chat or the question, or think about for yourself, like on balance. I will tell you that the ethical civil rights accessibility lawyers I know, we all know that it's much harder to convince judges that we're not that, and to have understanding for the real barriers that disabled people face because of these lawsuits since 2017. But it's just something, we're talking about 30 years of the ADA, and this is something that's cropped up. I think it's important that we know. But I think we go on to the next thing, which is, to me, kind of a side impact of the shark.
Oh, which is the quick fix software. Yeah, I know that you had told me that this was something that was of concern to you, and it is to me too. So did we get the new slide for quick fix software, Randy?
It's up. Yes, ma'am.
Thank you. So this is just visually, this is a page of code. I don't even know what they were coding. They could have been coding a moonshot for all I know. But we superimposed on that the idea that one line of code can't meet ADA requirements, and that you cannot make your website accessible in seconds. And that is just, people are saying all over the chat, I keep getting emails from companies promoting Section 508 services, and yet their own websites are not accessible. So carry on, Lainey. What do you think about these quick fix solutions from a legal and ADA standpoint?
First of all, I want to invite people to read some recent very good posts about some of these. I'll try to find it if we didn't send it in already. Adrian Rosselli and Steve Faulkner have written very detailed articles about what these, and we're not going to mention any names here, but what these companies that promise, this was a new one in seconds. This is like a new one. Last week, the quickest time, we guarantee accessibility in 48 hours, you know, and what they do is they put a line of code on your website, and Steve and Adrian, who are accessibility experts, did a lot of analysis of this. My friend Lucy Greco, who's blind, has done a lot of discussion about this. And I think in best case scenario, you're talking less than 30% of WCAG requirements. But again, where are the people? Where are the people with disabilities that need to understand what's on the website, confidentially and privately use their credit card, do whatever needs to be done? So I think we're going to learn more about what the ADA has to say about this, because now there are a few lawsuits pending where in the lawsuit, it was said this company used one of these tools and I still couldn't get to what I wanted to get to. So there's that. I'm also just almost brokenhearted, I would say, that these things are licenses. So you pay to get that line of code. The month you stop paying, you don't have that line of code anymore. So the reason I feel it's related to the lawsuits is because the lawsuits have created this fear environment, and I've written a lot about fear. And so not all, but many organizations that get one, they are looking for a quick fix. And any of you in the audience who have researched web accessibility know the very first thing that comes up are ads for these companies.
Well, Peter says, though, they're winning the PR war, that they are, at this point, they are winning. They are also winning the investment war. Like, they get all this venture capital money because of the lawsuits. There's this attention. And then it's like, oh, well, we'll invest in this quick fix software company because they're bound to make money.
Yeah. And, you know, again, optimistic. These are artificial intelligence products. AI has the potential to really benefit disabled people. The AI captioning is so much better now than it was even 6 months ago. Not that we still don't need live captioners. Thank you to the live captioners on this. And you know, it's like the shiny object. Everybody wants it. But if you're in accessibility, and I think that's why we need to, it's kind of like how I felt about not speaking up against the lawyers because, well, I'm a civil rights lawyer and these are web cases. Maybe I shouldn't criticize them. Same thing here. You know, I think we need to get the vocabulary to try to, and that's why I really recommend those 2 articles and others. Carl Groves has also written a lot of and done videos on this. We have to get the vocabulary to make people understand why this is not a good use of resources to get back to the principles of the ADA for inclusion. But
You know, I think that's true. That yeah, I can share one example, and then I want to ask you. All right, if this software, well, so recently on some social media channel, we got a thing from a nonprofit consultant. You're a nonprofit that works with people with disabilities. Did you realize that your website does not meet ADA standards, which, you know, already to me is a key since we've established that there are no ADA standards for web accessibility. But and then so I wrote back to him and said, you know, I'm a little confused that you would write to a pioneering web accessibility organization like ours with this claim. Where is your documentation? So then he sends me a link to, he ran the WAVE tool, which even the WAVE report says 0 errors, 0 contrast errors, 2 alerts that, you know, you need to manually check it. So then I wrote back to him, which I probably shouldn't have done, and said, you know, basically I said, are you an idiot? Although it's like, do you even know how to interpret this thing that you're sending to nonprofit organizations who probably don't understand it in the same way we do? You know, shame on you. I could not believe that someone would be so ignorant about what they're trying to do. So, just like somebody in the chat said, you know, you get people who say, let us help you with 508 compliance, and you go to their website and it's not accessible. So given that we know what not to do, Lainey, what would you say, and you can go to the next slide, Randy, what would you say are some effective, what does work to achieve the promise of the ADA on digital applications and websites?
Yes, so we have this illustrated with the blueberry muffin. Those of you who have heard me talk in the past know that I like the food metaphor because there's a lot of, it's not one line of code, it's many ingredients that make this muffin. I did write a post recently with links to all the food analogies in accessibility. So I want to give a shout out to Cordelia McGee-Tubb at Salesforce, who came up with the original blueberry muffin analogy, which is you cannot put the blueberries in once the muffin is baked. Just like you can't put in accessibility once it's baked. And quickly, the ingredients that I see, and these are starting to be ingredients that courts recognize too. Like there have been court orders about testing. You have to have a good testing program that is not just automated, you know, not just automated, manual with disabled people. Transparency is an ingredient. Training is an ingredient. Our settlement agreements from the beginning have always recognized training as a key component. Develop to standards, design to standards, inclusive design. I really want to give a shout out to Adobe that Matt May and his team are making their inclusive design trainings open source. And you can go to the Adobe Inclusive Design website. Maybe somebody can put that in the Q&A. And they're sharing everything they've done. And it's a good reminder of the intersectionality, because when companies like Adobe and Microsoft, who also have a great inclusive design program, talk about inclusive design, they're talking about people with disabilities. They're talking about Black people. They're talking about people in rural areas. They're talking about women, you know, designing so that everybody can use the product. Procurement, so important. Procurement, part of the muffin. And hiring people with disabilities. Hiring people with disabilities is probably the first thing you can do to help make your products and services accessible, because I did a presentation with Microsoft lawyer once, and she said, you know, if you're sitting next to a deaf person in the cubicle next to you, probably you're gonna be less likely to put out a caption without, to put out a video without captions. So those are the ingredients to bake in accessibility, which takes time, not 48 hours, which takes ongoing sustained commitment, not a monthly payment that you decide to stop making the minute the crisis of the lawsuit goes away. And if you do all those things, then I now show my prop of the salt shaker, because of course we need compliance with the ADA. Of course, the ADA is the foundation for the civil rights aspect of accessibility, but too much focus on compliance is going to be too much salt in the muffin. And anyone who bakes knows you have to have a little bit of salt in order to have the muffin be sweet, which is interesting. But obviously, if you have too much salt, it's a bad muffin. So if you do all the other things, if you put in all the ingredients, you are going to probably be in compliance. But if you let compliance be the driver, then you're going to run into problems, and you're going to rush to those other kinds of solutions. So those are my ingredients. Sharron, what do you think? I mean, you help organizations all over the country bake in accessibility. What did I miss?
I think you hit a really, really key ones. I think the only one that I would say, big +1 to hiring people with disabilities, because of, that's how you understand the poor principles. That's how it all becomes real to people, is when I've seen so many developers, they want people to be able to use what they do. And if they see people with disabilities hitting those barriers, it becomes a problem to them as well. But I would say maybe that would be the second thing to do, because I think first and foremost, your company policy, your company or organizational policy and commitment has to be explicit. So develop that, and most organizations these days do have some kind of diversity and inclusion statement. Make sure you're very explicit that you're including disabilities in that inclusion statement and in your policy statements. And the reason, to me, that's important is because then all the way along the line, in the procurement department, the training, the developers, they can point to that policy and say, but XYZ company says we are going to be accessible in all of our physical places and communication channels to people with disabilities. So I think policy is also something that's really important, and keeping the poor principles in mind. But yeah, you hit it. You were good. I think integrating accessibility too into the life cycle of your products or websites or whatever your digital products are, is that if you integrate accessibility thinking, you're not just putting it on there at the end. Oh, at the very end, you have the accessibility checker come through. No, you want to make sure that everybody understands, and that goes back to training. So I think now we should maybe answer some of the questions that have piled up in the QA. You want to do that before
Yeah, that's good. But there's one word that we didn't say. I totally agree with you about policy. We didn't say the word culture.
Yes.
That's what it's about. And there are so many, I do some work with Disability In, which is a business to business diversity, inclusion, accessibility nonprofit. And I see from, we already mentioned Microsoft and Adobe, but so many leadership companies and companies that are large or small, so many great ideas. You do not have to reinvent the wheel. To have, how do you break down the silos? Do the HR people know what the accessibility people are doing? Do the design people?
Exactly. That's what I meant about integration. Yes.
That can be as simple as, brown bag lunches or champion programs. I am a big believer in champion programs. If anyone has a link to, I know that Ted Drake at Intuit does a great job in talking about their companies' champion programs. LinkedIn has a good program. They all do. Microsoft just made their champion program public. There's some aspect.
I know it is. It's really, I really do feel like Well, we're going to get to our predictions here in a minute, right?
Okay, predictions.
So, but wait, no. Well, let's answer some of these questions. We've piled up some questions here, and we've invited people to
okay, questions.
to do that. And here's one from Meredith. She works for a Texas city government, and much of her work is creating content for websites and Facebook pages. And she previously had worked for a disability network in Michigan, and at her current place at this Texas city that she nicely doesn't name, the city attorney has told Meredith that the city is not responsible for providing any ADA accessibility services for digital services such as closed captioning in any online communications. She wants to know, is this correct?
Am I supposed to answer that question?
Yes, ma'am. You're supposed to. You're the legal eagle here, not me.
Well, okay. This is where I say it's not legal advice, and I'm sorry, I got momentarily distracted. But the idea of the ADA for government is that the government is supposed to be the government for everybody, and there are lawsuits out there. There's been a lot of lawsuits in Florida about government agencies that are not providing captioning or sign language. I think most of the cases are about captioning, not sign language interpreters, of public meetings of all sorts. I mean, this was an issue before COVID, but we could do another whole talk about how all these issues, everything we talked about today is just highlighted and magnified because of COVID. There was a case in New York on making sure there was a sign language interpreter for COVID information because all information, like we said, from the ADA at the very beginning was about making sure information is available in various formats. Here we're talking about health and safety, life and death information. So,
yeah. Okay, so one more question. We have a bunch of questions. We probably won't get to all of them, but I think that this one might be something that you can relate to. The question is about unethical ADA lawsuits. And in your opinion, have those impacted the ability of job seekers with disabilities to access employment mainstream, which then makes employers more scared of hiring people with disabilities?
That's a really good question. I do think, I don't know specific, I haven't seen any studies on that. I haven't heard about any cases, or I haven't even heard direct stories, but I have talked to a lot of people with disabilities about these lawsuits, and not everybody, but most people feel that it's creating an environment. We just talked about a good culture. There's also a bad culture. And when you have an environment where people see a disabled person and say, oh no, here comes a lawsuit, that's bad. And that is why I have come down on the side, even though there may be some advantages of drawing attention, that I've come down on the side that these lawsuits overall are bad for the ADA and bad for people with disabilities, because they just don't have the focus on real problems, real people. And then you try to either apply for a job, or you make a complaint to your local government or to a local store. And instead of first seeing, oh, we have a problem we want to fix, too many companies see, oh no, here's a troublemaker.
Well, and that's what, we just got a comment in the chat from Peter Slayton, who said that's why they're winning the PR war, because fear is such a strong motivator.
Yeah, I mean, I've written on my website, you can look up fear and read some of the stuff I've written about that, but the whole civil rights aspect of this and the inclusion aspect should be something great. And, Ted Drake, again, and Intuit, they have a system where they go through their call-ins from customers. And, some people say, I have a disability complaint, but other people may say other things that are related to disability, but they don't say it expressly. And they call all those out and they handle them as civil rights complaints. One thing I should say is, in structured negotiation, as I talk about in my book, we don't use the word plaintiff, which is, the name of the person who files a lawsuit. And I always wanted to change the vocabulary of of litigation to collaboration and not talk about fighting and this and that. So when I was writing my book, I looked up, like, what does the word plaintiff mean? And the word plaintiff, the very word itself, means wretched complainer. It's,
Oh, no.
etymology, whatever that word is, root is wretched complainer. And instead of seeing people, here's an amazing civil rights law that we are celebrating 30 years of, and I want to, bring it to fruition, it's like, oh, stop being a wretched complainer. And I think,
oh gosh, that's really funny.
What an impact.
All right, so I've been trying to answer the questions in the QA. We may have to do some of those after, because we do want to hear, I mean, we promised our attendees that we would tell them something about what do we see coming. And I think, Randy, if we look at the next, we found a little crystal ball that is reflecting the surrounding world and the sky above. And we're going to ask Lainey for her forecast of what is to come, Lainey, in this world of digital accessibility and the ADA and equitable access for people with disabilities.
Yeah, well, I don't have a crystal ball prop, but
well, that'll be for next time.
One thing I struggle with being a lawyer in this space is the law is very slow and technology is fast. So in the law space, we're still talking about website accessibility with Domino's, and in the last year, we're talking more about mobile app accessibility. Like I said, I've been working on mobile apps since we don't fight in court and we can collaborate. When we work with Major League Baseball, we started with their website, then the App Store opened in 2008. We didn't have to file a lawsuit because we had a great relationship, because we were working with blind baseball fans in Major League Baseball. We said, well, now you have this great app in the new App Store, and the ADA, because of all these general principles, applied, and then so we worked on the app. But what about, augmented reality and mixed reality and virtual reality and all these other types of reality? Like, what's the law going to do about those? And we don't even know what the next technology is and how long is it going to take. So I think that there's, going to be a slow, steady march to inclusion in the digital space, because first of all, COVID's not going to be the last. First of all, it's not over. It's not going to be the last situation we have where people have to rely on digital. And so I think there is a steady, like Martin Luther King says, the moral arc of the universe is long, but it bends towards justice. And I have to believe that. We haven't seen the law touch cognitive accessibility, which the Web Accessibility Initiative and the WCAG drafters are working on and have worked on. Most of the legal stuff started around blind people because accessibility was such a lack of access, such a showstopper for blind computer users. And as we saw more video content, we saw more deaf people and people who are hard of hearing involved in the law, because you need captionings. And I think we'll probably see, as we have more standards around cognitive and how they're, we'll see more of that. And we'll probably see more lawsuits. I don't know if I'm with Peter. I don't know if we've totally lost the PR battle, but I think we're going to have to keep fighting the PR battle. Sharron, what about you? What do you think?
Oh, I'm a terrible person to ask about forecasts. Remember me? I'm the person who started the AIR program thinking, oh, once the professional tech people are aware of this problem, it'll all be solved. I mean, I have no ability to forecast. Honestly, I did. I thought, oh, we'll just raise awareness of this issue among all these really smart technology people, programmers, designers, developers, and they'll solve the problem, and we'll all live happily ever after. Talk about optimistic. I really expected that would happen, and then we would move on to solve problems of world peace and general health and all those types of things. But so I don't think I have a good idea. I think the things you talked about with artificial intelligence and virtual reality, I think those are going to be fascinating because there is so much potential benefit. I mean, it's just like the internet itself. When if people with disabilities who are less able to be mobile around the city to get to work and to do that could work from home and have the resources they need, then okay, that's the problem solved. Same with kiddos. You know, we've got kids with disabilities at home now. All of their supports are missing. All of their supports are gone. And these kids who had some resources, at least in the classroom, are now completely locked out because the resources. I mean, K-12 accessibility is one where there needs to be a forecast of some serious, fundamental, foundational change in the way they try to integrate kids. And so I would hope for change there, but like I said, I'm not a very good predictor. So what about y'all out there? Are you putting stuff in the chat about what you think is coming?
You know, while people answer that question, there's a good question in the Q&A about why there aren't more disabled people who are professionals and managers. And the chatter says, there's not a single Fortune 500 CEO with a physical disability. I think that is discrimination from, you know, first of all, I don't know if that's true or not, but just that obviously it is true that there are not as many disabled people in high positions as the population indicates there should be. I do take heart in, again, the leadership companies in accessibility. Microsoft just did their Microsoft Summit, Ability Summit. Jessica Rayfuse interviewed the head of HR there, and he talked about how he never wanted to share that he has MS. And as the culture, again, culture grew, then he became more comfortable. And actually, it was like I think he was head of HR. I'm sorry, I don't have the name. If anyone was there, you can mention it. So I think we have a lot of work to do. I think that the employment side of the ADA has been its biggest shortcoming, its biggest failure. We just haven't gotten the number of disabled people into positions as we should. And I think technology is going to play a bigger and bigger role in that, especially as more people work from home, which means we're going to see more lawsuits. We're starting to see lawsuits about workplace software and online application portals. And I think we'll probably see more of that. And yeah.
Dina made the point that even though there aren't CEOs, there are many small business owners with disabilities.
Absolutely. Who we should try to be supporting. Yeah.
So I think the last slide that we have is just our contact information. And so we're at 3:20 now. We have 10 more minutes. Should we just keep answering these questions? Best practice to make virtual public meetings accessible to all people with disabilities. Oh my gosh, we just did our, we have an annual conference called Access U that we just reinvented as an online conference in May. We had one major meltdown where all the technology crashed. We used Zoom, we had live captioning, we had ASL interpreters for the live events, for the like social events and keynote talks. And then we had ASL available to attend the sessions in by request only. And it was interesting to try to think about all, you know, you can't expect people to ask for what they need when they don't necessarily know. Maybe they haven't attended an online conference before. So we tried to anticipate, and I think we did a pretty good job for the first time. But this question also says, what about people with disabilities who don't even have internet or have a computer? And is public TV with captioning or some other accommodation an effective method to provide access to people with disabilities who do not have internet or a computer? Are there any other best practices? Do you have any answer for that, Lainey?
I don't really know about the television option. I do know that that question reflects the digital divide that is intersectional in that the number of households with a, I was just looking at the numbers from a 2011 report, and I wouldn't be surprised if the percentages weren't that different. About if there's one disabled person, you're like, your household is 15% less likely to have access to the internet.
Wow.
And same with, you know, they put them in separate categories. If you're rural, if you're poor, if you're African American, if you're other ethnic groups, if you're a person of color, whatever, and disability cuts across all that. So I think the questioner is good that in these conversations, we're talking about access for people who have the ability to use websites, but so many people, and especially when you want to talk about global, who are disabled don't even have that access. I want to give a quick answer to an unrelated question to that. Can you speak to key TAM lawsuits, which are lawsuits, this goes to my favorite lawsuit, which is why I want to mention it, which is lawsuits where somebody sued, the state of California bought a website. It was supposed to be accessible. They paid $66 million because it was for their whole park system and the reservation system. And it was not accessible because they did not have a culture and they did not have a good procurement process. I think we have a link in here for the Disability and Accessible Procurement Toolkit, which I worked on and I recommend. So there's a lawsuit pending against the developer of the website to get the money back. I forgot what key TAM, I forgot what that stands for in Latin, but it's when somebody makes a false claim to the government and says, here's our website, it's accessible. Here's our software, it's accessible. Buy it, but it's false that it's accessible. And I think depending on what happens with that lawsuit, we're going to see more of those lawsuits. And we're going to, in the legal space, I didn't mention before, we're going to see more lawsuits against the developers, against the vendors who are selling inaccessible products, because the ADA, I should have mentioned this at the front, you're not supposed, it was so flexible. Where's my flexible thing? It was so far-sighted and flexible. It talked about you can't interfere with someone's ability to meet ADA requirements. And you can't violate the ADA yourself or by contract. So all this, I think, is going to come up in the web accessibility lawsuits. And that California case is brought by a civil rights lawyer named Tim Elder. The case is called Bashan versus Conduit. And on my website, lflegal.com, you can look up 66 million, search 66 million, you will find that lawsuit. So good question.
So there's another question about broadcasting city meetings that are open captioned. And then they also provide ASL, and sometimes the ASL obscures, or the graphics, when there are lower titles and information, the graphics obscure the signer's hands or face. Would that make the meeting out of compliance? I would say no, but I don't really, I mean, because it seems like you're, oh, I don't know. I don't really know. It's a temporary thing, I'm assuming.
Well, you know, it's interesting, and this is, I do Zoom all the time, but this was the first time that I've seen the stream box where we don't have to worry at all about, are the captionings covered? Again, if we go back to what it's all about, it's about participation. And if the setup is such that you cannot see the captions, then you can't see the captions and you can't participate. So, you know, like Sharron said,
Yeah.
Again, this isn't legal advice. If it's a short-term thing, someone puts up a picture for 2 seconds and then it's off, but basically it's fine, it's fine. But if it's a setup that guarantees you can't see the captioning, that's not participation.
I agree. And then Gary Morin asks about automated speech recognition software captions versus the deaf employee wanting human typed cart-like captions. You know, we had live captionings at live captions at Access U, and we had a couple of deaf presenters. One of them called the automated captions craptions, and that was actually in the title of her presentation, because they are getting better. There's no doubt about the fact that artificial intelligence is improving, but they are getting better for people who speak standard English with not any kind of an accent and at a regular clip. But for people who speak really quickly or who have quirks in pronunciation, just a few mistakes can really obscure the meaning. So I don't think that, I mean, if you're doing your best to provide captions, I'm not sure you would be able to make a legal claim. And that's where, again, I think culture and the idea of inclusion and striving for your best, that's where I think budgeting and planning and policy all are really an important part of delivering an accessible experience. And so you want to make sure you've got that kind of support throughout your whatever the organization is.
You know, Larry Goldberg, thanks for mentioning xraccess.org. And I should have clarified that when I'm talking about will the law get, you know, where's the law going to be on, you know, XR and VR and all that stuff. Amazing work goes on without being in the legal space. You know, it's like the gaming industry is just doing amazing advancements on accessible gaming, and the XR community is doing amazing work. The question is the law going to be supportive of that, or is the law going to be a hindrance? And Peter, I want to clarify, you didn't, okay, thank you. You didn't say the PR war was lost. I'm glad to hear that. I'm glad to hear that. We're going to fish it.
Well, Lainey, we only have 3 more minutes, so I think we should let these people go. There's a couple of ones that we didn't. Will equity become part of the mix because communities affected by equity are disproportionately affected by disability? I think Lainey did kind of address that one. But listen, you've got our contact information. Let's keep the conversation going. Lainey's pretty awesome on Twitter. She's always, seems like anytime I go on, she's there with her great insights, and it's been a blast to be here with you guys as always. Thank you, Randy. Thank you, Ron, Lucy. Thank you to the Governor's Committee for making this time available to us. Thank all of you for coming, and especially thank my friend Lainey. Thanks for being here with me. This was super fun.
Fun. Thank you.
Really, really great information. Thank you both ladies. And I'd like to thank our 21 partner entities for this event. The American Council for the Blind of Texas, Adaptive Texas, Art Spark Texas, Coalition of Texans with Disabilities, Disability Rights Texas, Governor's Committee on People with Disabilities, Knowbility, the National Federation of the Blind of Texas, Community Attendance Equal Independence, Rev Up Texas, Southwest ADA Center, Texas Association of the Deaf, Texas Council for Developmental Disabilities, Texas Department of License and Regulation, Texas Department of Wildlife, Parks and Wildlife Department, Texas Workforce Solutions, Texas Workforce Commission, Statewide Independent Living Council, the ARC of Texas, University of Texas at Austin, Texas Center for Disability Studies, and the Texas Department of Transportation, all coming together to make this happen. I thank you all for joining us today. We will get the information, the materials to you after the session. It'll probably be August. And the links that we share today, we will also share with those materials. Have a great afternoon. Bye-bye.
Bye.
Thank you. Bye. Thank you.